Hi, everybody. Thanks again for joining us for our estate planning and protection webinar. Of course, in times of crisis, that's what we're dealing with these days. So I want to thank you again for registering. And bottom line is, as we get started here, the concept of estate planning, the concept of protection, all of those issues that we'll be going through today, the bottom line purpose of estate planning, or planning in general for that matter, is to set out what you would like to have happen if a certain situation arises. It's not science, and it's not something we can predict. So a plan needs to be as comprehensive as possible to cover multiple scenarios. And every plan, if it's a good plan, requires as much flexibility as possible in case there's a curveball or something unexpected. So, what do we need to plan for as we get older? What risks are we trying to mitigate? The first scenario everyone thinks of is passing away. And how do I know this? Because everyone says, oh, I need a will. That is a risk that needs to be planned for, but it's only 1/3 of the battle because there's a lot that can happen between now and that day in the future when we pass on. And there's a lot that can happen after we pass away between our assets and our beneficiaries. And we don't want our hard-earned assets lost as soon as we pass away. The bottom line is that we need to plan for 3 different segments. We need to plan for the potential health and long-term care issues that will probably arise for me in some form or fashion between now and when I ultimately pass away. And secondly, I need to plan for how my assets will pass to my beneficiaries. And third, I need to address the contingencies that our beneficiaries may be facing as they are receiving our inheritance from us. Picture it this way. It's like a timeline broken into 3 different sections. The first segment is from today until I pass. The second or middle segment is the process of our assets transferring to our beneficiaries. How are they inheriting? And then the final section is what happens with the assets when they actually land in our beneficiaries' laps, okay? So it comes down to this. If we know exactly what would happen to us and when it would happen, and if we knew exactly what would be going on with our beneficiaries when they inherit, then planning would be much easier. But we don't know either of these answers. So again, we need to be as comprehensive and flexible as possible to cover all of the potential circumstances. We just don't know what's around the corner, so we need to cover all of our bases, okay? So let's talk a little bit more about the possible risks and situations that we do need to plan for as we age, okay? And there's one significant but basic concern that people focus on when the topic of estate planning comes up. So let me share our screen again here. All right. Let's go there. So hopefully you can see right now the actual presentation. Can I get a thumbs up or a yes, you can see the presentation on the screen? That would be great. Anyone? Anyone? Okay, great. Thank you. Okay. So here we are. Now, our primary concern, the basic concern, is where will my assets go when I die? Okay. This translates into, okay, I'm going to die at some point. All right. This translates, as I was saying, as to where are my assets going to go when I pass? And that translates into, okay, I'm going to pass at some point, but who's going to inherit my stuff? That's only one simple question. Answering this one basic question does not, let me get rid of that line there. Okay, sorry. Answering the one basic question doesn't create a plan. It just creates a document. It's a very basic document called a simple will. And that might or might not address the most common and elemental risks that we can face. Now, who here thinks that a simple will solves the planning problem? It doesn't, because none of our lives are this simple. None of our lives are that black and white. So depending on your family and your facts, meaning your situation, you will have other potential risks and concerns that must be addressed and accounted for in your plan so that your wishes and intent may be fulfilled. Okay? And on that note, you may not even know the risks that are out there. And when you tell a general lawyer or a website like LegalZoom that you need a will, they become merely an order taker and they're just fulfilling your request. They don't advise and they don't counsel you on the potential risks that we all face as we age and as our assets pass on to our beneficiaries. On the other hand, an attorney that focuses on planning will be able to share what the future may hold, the good, the bad, and the ugly. And when we do that with you, we are literally walking alongside you as you think about and imagine what the future may hold for you and your health and your loved ones. And then it's our job to translate that into a written plan that addresses the potential good, bad, and ugly. And it also finally ensures that your wishes and intentions are being fulfilled. Okay? So it's much more than the one question of where will my assets go when I die? There are many other risks and factors that must be addressed when planning. For example, here are some more additional concerns that will impact your plan. For example, are you over 65 years of age? Why does that matter? Well, if somebody is over 65 years of age, then they're facing different concerns and risks as they get older. A tremendous part of our practice is helping older folks plan and protect their assets for when they get older and potentially need long-term care. So a plan for a 30-year-old is going to be very different from somebody over 65 years of age. There's different risks, different assets, different intentions, okay? So that's one factor. Another one is, are there health issues? And this could be any age. We have represented and helped younger disabled folks with their care issues and advocacy issues and asset protection issues. But of course, as folks are getting older, we deal a lot with the chronic issues and the long-term care issues. So if a health issue exists, that's going to change the plan. In addition, do you own real estate? Different assets will cause and make other planning recommendations more optimal. Do you have real estate in other states? That leads to different probate proceedings in different states, which is a whole nother situation. Again, another factor that goes into the planning equation. Another one that we do see is, are you disinheriting a child or leaving different percentages to different children? When you do that, that is ripe for what's called an estate contest. And not only does the attorney need to make sure all the T's are crossed and all the I's are dotted, but they want to actually do what they can to keep everything out of the court system. Okay? So another factor that has to be addressed. One we see quite frequently is, a child or grandchild disabled. Very important concern, because if there's government benefits being received by a potential beneficiary, then we need to have certain steps built into the plan to shelter the inheritance and keep the beneficiary eligible on those government benefits. It has to be put in the plan. Does a beneficiary have personal issues? This is every family, even my own. Every family has something going on. And whether it's a disinheritance because of perhaps there's an addiction issue, perhaps there's an incarceration, bad financial decision making, a spendthrift, a rocky marriage, or a bad relationship that the parents and the family don't really think that it's the best match or healthiest relationship for the child. Those types of personal issues will impact how the planning is going to get completed for down the road. That's that third segment I was talking about. You don't want an inheritance landing in the lap of your son who's in the middle of a divorce. You don't want your inheritance just landing in the lap of a child that has an addiction and is struggling with that. So again, all these planning issues have to be addressed as the plan is being developed. Are any beneficiaries under 25? Your gut reaction might be, no. I have adult children. I've got 3 adult children. They're going to be my beneficiaries. Okay. The concept of contingencies starts to come out. What happens if, God forbid, a child predeceases you? Where does that 1/3 share go? Typically, it goes down the bloodline to minor children, minor grandchildren. Okay, so we need to plan and protect inheritances for when beneficiaries are older. The last thing we want to do is have an 18-year-old inherit $500,000, 19, 20, 21 years of age, because we know where that's going to go. It's and where it's not going to go. So holding on to money and having a gatekeeper, if you will, until they hit a certain age is a crucial decision. Is this a second marriage? Other concerns, all right? I've seen scenarios where a husband and wife come together for the second time. Wife has 3 children from the prior marriage. Husband has 3 children from his marriage. What's going to happen with those assets? Do they go from husband to wife at the first passing? What happens if the wife remarries? Are the 3 children from the husband excluded? So these again, and you can see the complications, need to be spoken about and addressed. Another one, which we don't see that much these days because the estate tax thresholds are so high, but there are clients out there with significant net worth, and then they have to undertake estate tax planning in addition to all these other concerns being on the table. And finally, do you own a business? Entirely another area of law. There's business succession concerns, there's buy-sell concerns. An example is if a husband has a business and he passes away, his will or trust is going to probably leave everything to his wife. At that point, she may not want the stock in this business, but the husband's partners that are surviving might. So you need to account for that in the planning, okay? Again, the family issues, though, are what we mostly deal with. The disabilities, the children with issues, handling assets in other states to minimize the estate proceedings afterward. Each of these have to be addressed, okay? And each of them will add an additional layer of thought or planning to your estate plan. And if one of them isn't addressed, it can be a landmine. It might not be, but guess what? It really could be, okay? And addressing those potential risks is what planning is all about. So in my 22 years of helping clients plan and protect their wishes and their assets, I've personally seen each of these, unfortunately, blow up for a family. And it's not something you want your family to endure, okay? But this is the type of comprehensive, in-depth planning that we do here at Tully Law. If you're just here to learn about a will, then please enjoy the webinar. But in all reality, that may not be a good fit for you. We may not be a good fit for you. It's my hope, if that's you, that you'll see the risks and the benefits I'm going to lay out and undertake a more comprehensive, real life plan for yourself, your loved ones, and your assets. Because this stuff is real and it happens every day. All right, so let's get into this. There are 4 avenues of planning, 4 different ways that we help families plan. Each of these 4 options is a road that you can take. And at some point, you'll reach the destination that you've chosen. It can be a dead end, all right, with a lot of unnecessary stress, as you can see, as you could try to do a 15-point U-turn banging into garbage cans and fire extinguishers. Or it can be a nice, warm, sunny beach. Where are you headed with your plan? What's the end that you have in mind, okay? And as you pick the road, you may have guessed it, based on your situation and the concerns that you want addressed, then you'll be on the track to reach that destination, okay? So let's look at the different possibilities. And while we're looking, by the way, at this nice beach, which I'm sure we'd all appreciate to be on right now, let me share that all plans are made up of 3 things, okay? Number 1, it's the advice of the experienced estate planning or elder care attorney that you're working with. Secondly, it's the documents that he or she is implementing based on your circumstances and your wishes and your family. Third, trust. There has to be a level of trust and relationship between the counsel and the client, between the attorney and the client. What you'll find if you're working with us is that relationship is a major issue. These are not hit and run transactions after we spit out some boilerplate language out of the printer. We're talking about your family, your loved ones, your wife or your husband, your children and your grandchildren, your nieces and your nephews, as they grow and what you want best for them. Okay? That's what this is about. Your estate plan is your legacy, whether it's good or bad. This is how your loved ones will probably remember you. These are the plans that we've implemented for ourselves and for our own parents and siblings. Okay? So bear in mind again, the documents, the written documents are just one part. The advice and the relationship, the trust, are what these documents are built on. All right? So, our first avenue or choice of planning is what's called a probate plan. This first basic plan is for the younger, healthier client on a budget, perhaps less wealthy, still generating and earning. The concerns are minimal and the facts are pretty simple and pretty straightforward. Generally think this type of plan is for somebody in their 20s through early 40s, okay? It consists of a last will and testament, as well as a durable modified power of attorney, a healthcare proxy, and a living will. All right. Now, let me explain each of these. A last will and testament is a very important document. And yes, it can be a simple will, but most often that's not the appropriate tool that a client needs. A will is the document that will distribute your assets after you pass away. Okay. And as I'll get into in a slide or two, there's different ways that we own assets when we do pass away. If we have assets in our name alone or solely owned, then those are the ones that are going to go through the will. But, and I get this question a lot through the years, if I have a will, why do I need to go through the probate process? And the bottom line is that a will is technically not even a last will and testament until the court says so. And that probate proceeding is a validity proceeding to determine whether the will is legitimate. So the will itself, important document, a cornerstone document, but it is only valid if it goes through probate. And we'll talk about probate in the next couple of slides as to benefits or really cons of it. All right. The will should have different contingencies built in, like I shared. Do we have a minor child inheriting or possibly inheriting? Do we have a child or a grandchild with disabilities, perhaps on government benefits? All those types of contingencies need to be built into the will. Okay. Durable modified power of attorney, probably the most important document there is. You'll hear me say during a consultation that the document is worth its weight in gold. It's where you are appointing somebody to handle your financial and legal affairs. It's somebody you trust, somebody you can rely on to literally stand in your shoes as a fiduciary and handle your affairs. What's in your best interest is what they're going to be handling and how they're going to be handling it. Okay. The power of attorney, it shouldn't be a complicated document, but New York has unfortunately made it a complicated document. It's broken into two different parts. The first part of the power of attorney is the typical old-fashioned delegation of authority. It's where you say, I appoint Bobby to be my power of attorney agent, and he can handle A, B, C, and D for me. That's the first part of the power of attorney. The second part of the power of attorney is where it got a little more complicated back in 2009 and tweaked a bit in 2010. It's where they've added a document called, or a rider called a statutory gift rider. And these two parts make up the power of attorney. Now, what does durable mean? Durable means that the power of attorney will remain valid even if you lose capacity. It is the only type of power of attorney that should be implemented when you're talking about estate planning, okay? Modified. Modified is interesting, and you'll see a lot of attorneys don't use that word in their title, durable modified power of attorney. I do it on purpose because the modifications are so crucial, okay? So again, there's two parts to the power of attorney. The first part is the traditional one, and then you have the gift rider. The gift rider is not about necessarily Christmas gifts, holiday gifts, birthday gifts. It's about asset protection. Okay. So it's only in that gift rider where your agent can protect your assets, can protect your income, can deal with Medicare, Medicaid, etc. Okay. Now, modifications. Each of those halves have a modification section. And the modification section very literally needs to be inserted and expanded. There needs to be a number of modifications added to each power of attorney, especially one dealing with potential elder care issues down the road. And every plan that we prepare, even if it's for a 40-year-old, is looking down the road at elder care issues and estate planning issues. So those modifications are where we'll find those extra powers and extra authorities, okay? I have to admit, it's probably once a week where we're sitting with a client and they're coming in with a power of attorney. And A, it either doesn't exist, right? They thought they have one, they don't. Or B, it doesn't have the modifications in there, or it doesn't have the right modifications in there. And very honestly and unfortunately, that's when you have to implement a new power of attorney that deals with the appropriate modifications based on what the future is going to look like for you and for your family. It's unfortunate that clients get these powers of attorney by other attorneys that don't specialize in this type of work. And again, the power of attorney at that point needs to get redone. Why? Because if you have a power of attorney with the wrong powers or the wrong modifications, or you don't have a power of attorney at all, and if your mental capacity is lost or declines to a certain point where you're unable to handle your own affairs, that's when the family is going to be forced into something called a guardianship proceeding. A guardianship proceeding is literally going to court and having the judge adjudicate mom or dad to be incapacitated, and then give authority and rights about personal health care decisions and assets to the petitioner, usually a child. Okay, so a guardianship proceeding is something that has to happen if there's no power of attorney, or if the power of attorney is insufficient and again, capacity is diminished. Something that can be completely avoided with the right, comprehensive, durable, modified power of attorney. All right. So, healthcare proxies. A healthcare proxy is the document where you can appoint one person to make healthcare decisions for yourself. It's in writing. It's the best way to do it. So you get to decide who does it, and they only get to make decisions for you if you are unable to make the decision yourself. Okay. So with the power of attorney, you can name one or two agents to act at the same time. But with the healthcare proxy, only one at a time is allowed. Okay. The healthcare proxy is meant to be a simple and straightforward document that says, this is the person to make decisions for me, and they can access my private health information with the HIPAA. Okay, that's the healthcare proxy. Then you have the living will. The living will is the document that says, if I'm in an irreversible or incurable condition, I do not want any medical treatments that merely prolong the dying process. The living will is a crucial, important document. It is not the healthcare proxy. They are two separate documents, okay? Again, healthcare proxy to appoint the person to make decisions. The living will is the document or the guidelines that healthcare proxy agent uses to say, my wife or my husband didn't want to be this way. They did not want life-sustaining measures if they were at the point of no return, okay? The living will deals with respirators, ventilators, diabetes, dialysis. It deals with antibiotics. The living will always say, again, if I'm at that point of no return, let me go, but do provide me with pain medication, okay? Again, it's meant to be two separate documents. We find that that's the cleanest way to do it. If you have a healthcare proxy with living will language already built into it, we prefer to have it as two separate because I believe that it is a better way to kind of keep the family in control of the conversation, giving the healthcare providers, who deserve all of our praise these days for sure, but giving the healthcare providers the living will language and the living will intent when it's not yet time for that just muddies the waters. Okay, so again, last will and testament, power of attorney that's durable and modified, healthcare proxy and living will. Those are the basics. That's the foundation of any plan, but it's what's called the probate plan. Okay, so remember in the beginning, I said that there are 3 segments to planning. Okay, like a timeline. And if done correctly, the probate plan can accomplish all 3 parts, mostly. It starts to help and address what can happen between now and when you ultimately pass away. That's what the power of attorney and the healthcare proxy is for. It addresses the how, the process of the middle part. How will your beneficiaries inherit? And the answer is here through the will and through probate. And it can even address some of the beneficiary issues that may exist if the will is done with the contingencies I mentioned earlier built in. Okay, so this is a sufficient plan provided you fall into that younger bracket with the simpler facts. As I said before, the probate estate plan, it's the foundation. It's the first step for all the other plans. And the other three plans all have to have these documents built in, okay? But the plan is not the most efficient avenue to take. There will certainly be, and I'm going to use this analogy throughout, with a probate plan, there's going to be a lot of traffic and there's going to be a lot of potholes on this avenue, okay? We can actually pretend and call it the Belt Parkway at 7 a.m. on a weekday, all right? What you're going to find is dealing with the court system and dealing with probate, a lot of congestion, a lot of ups and downs, a lot of delays, and I'll get into that next, okay? It requires probate. So let's talk about probate and why it's something that should be avoided. So it's a court proceeding. All right. Probate is a court proceeding, much like that guardianship proceeding I was explaining earlier. Guardianship is the court proceeding during your lifetime. Probate is the court proceeding you want to avoid after you pass away. Both should be avoided and both can be avoided. Okay. And there's several reasons to avoid probate. First, time delays. You're dealing with a court system, all right, that is often overwhelmed, often doesn't have the full staffing that it needs or requires, and it's going to take a while for the court to process the papers. Suffolk right now is doing e-filing. Things are moving a little bit faster. Hopefully Nassau and the city will do that eventually, but there's time delays, okay, compared to other avenues. In addition, there is a 7-month creditor filing window in which an executor, which is the one in charge of the probate proceeding that you pick, is not supposed to distribute assets because there is a time frame in which a creditor can file a claim against the estate. And an executor is personally liable for any claims that they should have known about. So that 7-month window is meant to be adhered to before assets are distributed, okay? Costs and fees. 99% of the time, legal fees will be greater in a probate proceeding. And there's costs. There's court filing fees. There's different fees for certificates of what's called letters testamentary. So there's always going to be additional costs and fees. This is one of the biggest these days. A probate proceeding is public. The filings, the petition you file in the courthouse, either Mineola or Riverhead or Jamaica, Manhattan, what you're looking at is a public proceeding. And there are literally companies within those courthouses reviewing the petitions. And that petition will have your information, your names, your addresses, your children's names and addresses, the approximate assets going through probate. And quite honestly, in this day and age of identity theft and fraud, there's no reason to put your information out there. Okay, so keeping affairs private is a huge reason that I don't like the probate proceeding for our clients. Distributees, let me explain that. What the law says is that when we pass away and we're probating a will, every heir, every next of kin must be informed of the proceeding, and they literally have to sign off on it. Okay, so two potential problems. If you are disinheriting or leaving a different percentage for, let's say, Jimmy, your oldest son, and you have to go through probate, do you think Jimmy is going to sign off on these papers acknowledging he's receiving nothing or less? The answer is no. So probate literally gives a disinherited child a soapbox to come up and to start gumming up the works and slowing things down and causing problems. The other way this becomes an issue, and this adds to a lot of delays, is if a child can't be found or a next of kin, an heir, a distributee can't be found. And the court will require due diligence to locate them, hiring a genealogy company, doing A, B, C, all different efforts to establish that you've tried to locate them and you can't. This is where you can get into years. We have an estate right now. Yes, it involves Ireland and overseas, and whenever that happens, you can add a year or a year and a half, 2 years. And And that's a shame because now you have to start dealing with genealogical records overseas. So dealing with probate makes the next of kin get involved, and it's a good reason to avoid it, okay? Real estate outside of New York, I mentioned this earlier. Everywhere you have real estate, there has to be a different probate proceeding in each state. It could be simplified. It doesn't have to be a full probate like you would have to do in New York, but you have to deal with the probate courts in each state, typically what's called an ancillary proceeding. Can be complicated, but you know what? The reason I bring it up because it's something you can avoid. Don't undertake a probate plan if you have real estate outside of New York. All right. Now, this court backlog and closure, excuse me one second. This has to deal with where we are right now in the pandemic. The courts were closed for a period of time. They are starting to reopen. They're rotating staff. You better believe there's a backlog of files. And unfortunately, very unfortunately, with the amount of people that have passed on, the probate courts are going to be jammed for the foreseeable future. Okay. That's a risk and that's a problem. We are, Lord willing, getting through this hopefully soon. But what about 5, 10, 15 years down the road if it happens again? Okay. Staying out of the courts is something you should do. Then we have two topics about Medicaid, estate recovery and right of election. So if somebody's on Medicaid, which is a government program that can pay for long-term care down the road once you're eligible, then what happens is if you pass away, if that Medicaid recipient passes away with assets in their name alone, okay, that's going to have to go through the probate process. And that is going to trigger the county, the government, to come alongside and start filing papers against that estate to recover and take the assets that they use to pay for the care to begin with. So it's through probate where Medicaid gets paid back. You avoid probate, you don't have to deal with that. Okay. Right of election. Right of election is a law that says you can't disinherit a spouse. And if one spouse is on Medicaid and they pass away, that's one scenario. But if the well spouse, meaning the spouse not on Medicaid, passes away first, their plan is going to have their assets go to their children or other loved ones, not the spouse on Medicaid. Now, what will happen in that case is Medicaid will stand in the shoes of the Medicaid recipient spouse and file a claim against the estate of the well, healthy spouse that just passed, and they will collect a third. Now, Medicaid always has the right to do that, but when there's a probate proceeding, it opens the door and makes it happen, okay? Again, a final reason is Medicaid that you want to avoid probate, okay? Now, probate is necessary when you pass away with accounts or assets left in your name solely, like I said earlier, and this happens often. So how do we avoid probate? We want to avoid going to the courts, and we do it in one of three ways: by having accounts or assets jointly owned, by having beneficiaries on accounts, or utilizing trusts, okay? Now, a joint account is an ideal situation, an ideal way to avoid probate. It doesn't work for Medicaid, and you'll find that as we're talking, some strategies work for probate avoidance, but they don't necessarily work for Medicaid protection. But a joint bank account is a good way to avoid probate. Be careful with the joint owner, okay? Don't just put Jimmy on the account because he's your only child and you need a joint owner. There are risks associated with joint owners, and I call it the D's, okay? As in David, all right? The D's. If that joint owner dies, okay, that you no longer have a joint owner. The situation, the benefits are over, okay? Another one is disability. If your joint owner becomes disabled, what's going to happen? Your assets are going to count against him or her if they're applying for Medicaid themselves. If your joint owner gets divorced, you can rest assured that divorcing spouse is going to be going after any joint accounts, and you'd have to fight to keep it. Another D that you want to be mindful of when you're picking a joint owner is potential debt. So any bankruptcy proceedings or creditor claims or lawsuits against your joint owner will impact your assets. So again, joint is a great solution as long as it's the right joint owner. Beneficiary, okay? That's going to be your retirement accounts, your life insurance, your annuities. name your beneficiary, and clients come in here all the time and say, I have a beneficiary. I'm going to make sure you verify that, because beneficiaries, sometimes the form gets lost, sometimes the financial institution doesn't record it properly. So you always want to verify your beneficiaries, okay? And then trusts. So a trust, which I'm going to talk about next, is one of the best ways to avoid probate proceedings, okay? So let's talk about the next planning option, the next avenue. This is the second planning option. It's called the probate avoidance plan, all right? So we're talking about the simplest first, which is probate, and now we're stepping it up based on the nature and situation of what the client's needs are. And probate avoidance is a good plan to have. It's generally for the older, still healthier client, and perhaps one with more assets to consider, okay? So older, still healthy, and varied assets. It's where the concerns and facts, though, have a few more twists and turns. For example, if you're, like I just went through, if you're disinheriting a child, or if there's different percentages, or again, real estate outside of New York, if you're focused on privacy, if you're focused on simplicity for your heirs and your beneficiaries, avoiding probate is the way to do it. It keeps the courts and the delays and the extra costs out of the picture, okay? It's generally for those between 40s and 60 years of age, all right? Generally not older, because we'll be talking about the next plan for somebody older than the 60s next. But it is a plan for that kind of age range. It, of course, consists of the same 4 documents of the probate plan: the last will and testament, the durable modified power of attorney, the healthcare proxy, the living will. However, it now also includes what's called a revocable living trust, sometimes just called a revocable trust, sometimes just called a living trust. They've all come to mean the same thing, a revocable living trust, okay? And going back to our 3 segments of planning, that timeline, the probate avoidance plan also accomplishes the 3 parts for the most part. Again, it starts to help and address what can happen between now and when we pass away by having the power of attorney and the healthcare proxy and the living will in place. It addresses the how, the second middle part. That's the process as to how your beneficiaries are going to inherit, this time through the trust, not the courts. So it'll be faster, it'll be simpler, it'll be less expensive, okay? And it'll be private. And since it's a trust, it will have contingencies, at least it should, depending on what firm you have doing it. It should have contingencies built in to cover the contingencies and possibilities of your beneficiaries, all right? So that you can protect those assets once they're inherited. It's definitely an efficient avenue to take, okay? And to follow through with the analogy, the traffic will be minimal. There won't be potholes in this avenue, all right? So this one is kind of like if you've ever come home from the city at 1 a.m. on the LIE, smooth sailing, right? It's a straight shot. It should be simpler. It should take less time. However, you still might come across a danger or two. Why? Because you're going to have those 18-wheelers. You're going to have those tractor trailers zipping past you or going slow, and you got to be aware of them because they're going to be a hazard. The plan is great to accomplish most goals as long as the facts and the circumstances don't become too hairy, all right? This is the first time we've spoken about trusts. So let me take a moment and explain what they are and how they work, okay? Now, a trust is nothing more than a written agreement that manages your property or your assets. That's it. It's a written agreement. It's not magic, and it's not something to be intimidated by. And a trust is typically broken into 3 parts, okay? The trust will initially say, you, trustee, are managing my property while I'm alive and I am healthy. That's the first part. The second part is you're managing my property and my assets while I'm alive, but I'm not healthy. Perhaps I'm ill, looking at other circumstances. And finally, the trust will say, you're going to manage my properties and assets when I ultimately pass on and when I'm gone, okay? It's not more complicated than that. It's really not, okay? Now, every trust has to have 4 different parts, okay? Let me explain that. And to summarize before I actually get into that, it's a written agreement. It handles your assets during your life and after you pass away, okay? Each trust has 4 parts. The first part is the grantor, okay? The grantor is the creator of the trust, the one granting it. Typically, that's the client, okay? Sometimes it's called a settlor or a trust maker. I don't like those names. You're a grantor, you're granting it, you're setting it up. That's the first requirement of a trust. The second requirement of a trust is what's called a trustee. That's the manager. That's the one that's actually going to handle the property while you're alive and well, and handle the property when you are alive and ill, and then handle the property after you're gone, okay? You can have successor trustees in case the one passes away. Then you have the beneficiaries. This one's a little more complicated because there's different types of beneficiaries. You can have a beneficiary of the income, which is income that's generated inside the trust, or you can have a beneficiary of the principal, which is what's inside the trust, the actual assets, the house or the investment account. You can have lifetime beneficiaries, and then you can have future or death beneficiaries, okay? So beneficiaries is a little more complicated, but it's how we build the trust. And the final part, last element of a trust, is the property that goes into it. You have to have something in it. It's always why you'll see, perhaps on the last page, something that says $10, right? That's the symbolic $10 to create the trust and the management. It's often the house, the primary residence. It can be second homes. It can be vacation homes. It can be investment accounts. It's never going to be retirement accounts, okay? IRAs and 401ks and 403bs and qualified annuities, they stay outside of trusts, and they have their own reasons for doing that. Trusts are great, and we'll talk about the different types, but again, non-retirement assets, okay? Now, there's many different types of trusts, but for our purposes, we're going to focus on the 2 main types of trusts, all right? Which depends on what your primary goal is, okay? Is your goal going to be avoid probate? All right, avoid probate is the first main goal, and if so, then the revocable trust is going to be the way that you're going, like we just spoke about. Then the other main goal is protecting your assets. If your goal is to shelter assets and protect them, perhaps from Medicaid down the road, then the type of trust that's going to be in place is the irrevocable trust, okay? Now, the revocable, again, the top one there, it's all about probate avoidance. You are the grantor in the revocable trust. You are the trustee in the revocable trust. You are the full beneficiary in the revocable trust. So in the revocable trust, you are literally establishing a transparent entity to manage your own property and avoid probate when you pass away. All right. Again, you have a lot of control. You have all the control. You can literally set the trust up, and I say this to clients in the meetings, you can set the revocable trust up on a Monday, put your assets in there on a Tuesday, amend the trust on a Wednesday, put more assets in there on a Thursday, and revoke the whole thing on a Friday. You are fully in control of the revocable trust, so there's no asset protection. The irrevocable trust, on the other hand, that's created for the purposes of asset protection. And again, typically looking forward to Medicaid asset protection down the road. In that scenario, again, the client is the grantor, but the client is not the trustee. In order to gain asset protection, you have to start building a wall between the clients and the assets that are to be protected, okay? And naming a child or another loved one as a trustee, other than the spouse, that's one of those steps, okay? So for asset protection, the irrevocable trust is the way to go. Grantor is the client, trustee is typically a child, and the beneficiaries, this is where it gets, again, complicated, different beneficiaries, all right? Typically, the grantor is the beneficiary of the income, meaning if there's an investment account, they can get money, their interest or dividends out of it, but they're generally not, for Medicaid purposes, going to be the beneficiary of the principal of the assets on the inside. But the good news is these trusts are very flexible, all right? And money is able to come out of the trust. It's just not allowed to go back to the grantor directly. That's how you gain the protection, okay? But again, flexibility. In the irrevocable trust, you completely control who the trustee is. You can fire them, you can remove them. You control the beneficiaries. So you can say, I have my 3 children as my beneficiaries, but 5 years down the road, remember we were talking about Jimmy being a bad guy, if Jimmy decides to stop talking and stop being involved with the family, you can actually cut him out as a beneficiary. So even though it's an irrevocable trust, you are able to control who manages it and who ultimately inherits, okay? All right. So again, the probate avoidance plan, which is the plan option 2 that we were talking about, that other avenue, is the revocable trust, okay? Now, the third option or avenue is this elder care protection plan, as we call it, and it utilizes the irrevocable trust for asset protection. So let's get into this third avenue. Again, it's what we call the elder care protection plan. This third avenue is generally for those that are in their late 60s or older, but it can be for those that are younger if there are health issues. Okay, so an elder care protection plan is about protecting assets. All right, it's about dealing with future potential care issues and preparing for them. It is 100% an asset protection asset protection plan. It's all about, I'm getting older and I've worked hard my whole life and I don't want to lose my assets unnecessarily to the exorbitant costs of long-term care. It's realizing that you may need long-term care at home or in assisted living or even a nursing home, which of course we never push our clients to do. We always want our clients to stay at home. But it's also realizing that you can't afford or you don't want to pay for the exorbitant costs of care. Home care right now, you're looking at anywhere from $9,000 a month, upwards of $11,000 or $12,000 a month for live-in home care. Of course, it can be less if you're dealing with a couple hours a day here and there, but it is super expensive as care needs progress. A nursing home can be anywhere from $14,000 to $20,000 a month. Even families with a good retirement nest egg, even with assets saved up, you can blow through $250,000 in a year. So utilizing your own funds to pay for long-term care is not something that's very practical. It can leave the family destitute. So that leaves the Medicaid program to help pay for care, all right? And in order to gain Medicaid to pay for the care, in order to get those benefits, there's eligibility criteria, all right? So Medicaid will pay for care as long as you're eligible, and eligibility has to do with your assets, your income, and your health, all right? For our purposes today, Medicaid will certainly be that program for most of us to pay for care as we get older. The biggest rule in looking at Medicaid down the road is what's called the look-back period, all right? The look-back period is not an uncommon phrase. Those that have been involved with Medicaid at all know the look-back period. So there's now a twist, however. The look-back period has always been for nursing home Medicaid work. If somebody needs Medicaid to pay for the bills in a nursing home, there's always been a 5-year look-back period, okay, for all transfers. It's been that way since 2006. Now, what's happened, unfortunately, is Governor Cuomo in New York, in the latest budget that came out about 2 weeks ago, and it's been a part of the budget for years, but this time it's finally passed and now it's law, is that there is a look-back period for home care. It is a 30-month look-back period for home care. And prior to 2 weeks ago, people were able to plan on transferring assets, asset protection, et cetera, without having to think about eligibility for home care. Now, this new law for look-back, a 30-month look-back for home care, begins starting October 1st. Next Tuesday, a week from today, I'll be doing another webinar on the Medicaid benefits and the changes to community Medicaid, all right? So if you go to our website, tullyelderlaw.com, there'll be an opt-in for our email, and then we can get you the invitation once we get that processed later in the week, okay? So to learn more about Medicaid, again, next Tuesday, there'll be a webinar on the new Medicaid changes for home care. It's real unfortunate. The reason I bring this up now in a planning webinar is to say this: timing is everything. Even more so now that we have the home care look-back period, because you need to get the planning and protection established in order to get the 30 or 60-month look-back started and completed before care is even needed, okay? When we help families plan and protect this way with this elder care protection plan, like I said before, it's not a hit and run transaction. We come alongside the family and we help you prepare and plan for future care. Our elder care protection plan is where we build that relationship and support and help the family. There's annual meetings, there's updates to your documents that are included, there's guidance as to trust funding, Medicare help and guidance and assistance, as well as helping you start your family legacy. Okay? It's a very comprehensive plan. And honestly, I take great pride in helping families not only protect their life savings as much as possible, but also helping them prepare for future care and again, start that family legacy. This plan, of course, consists of the regular documents, okay? The last will and testament, durable modified power of attorney, a healthcare proxy, the living will, but now we're focusing on the irrevocable trust. That again is the asset protection trust. Okay? And again, going back to our three segments, of the planning, that timeline, this elder care protection plan accomplishes all three parts, but it does it in the most comprehensive way. Okay? Unlike the first two. Better than the probate plan, better than the probate avoidance plan. It now not only starts to address what can happen between now and you passing away with the power of attorney assistance and the healthcare proxy decision making and the living will, but this plan also protects your assets so that you can qualify for Medicaid down the road. All right. And it addresses the how. It's the process of how your beneficiaries will inherit. But this time, it's going through the irrevocable trust, okay? Which again, because it's a trust, it's faster, it's easier, it's less expensive, it's private, it avoids probate. And since it's a trust, it can address the beneficiary issues that might exist as they inherit the assets down the road. The irrevocable trust, when it's done correctly, makes sure your assets are still there for your loved ones when you pass away. That's key, all right? It makes sure your assets are going to be there when you ultimately do pass away. But as I mentioned a moment ago, the key to this plan is the timing. It needs to be done in advance. With these new Medicaid laws, timing is everything, all right? The longer you wait, the greater chance you have of losing assets and spending assets unnecessarily. The Elder Care Protection Plan is a definite improvement upon the probate plan and the probate avoidance plan. It is the most comprehensive avenue to take. Of course, there could be some traffic, but I promise you it'll be minimal. And there shouldn't be any potholes as you're going down with this plan. The best part is you don't have to worry about those big old tractor trailers and those 18-wheelers on the LIE. To continue on with the analogy, whether you love it or hate it, is that it's more like the northern state, okay? You don't have all the tractor trailers. It's a smooth ride. However, circumstances exist that you have to be aware of. You've got your curves, all right? You need to be mindful of what the future holds. So even a plan like this is not perfect, and you always have to be mindful of what's going on around you and what's down the road, and lean on us for help as you're aging and navigating, okay? Timing is real important, all right? You got it? Okay. So what's the fourth avenue for planning? I mean, what comes after protecting all your assets, looking forward, and starting to prepare for care? Well, the fourth avenue, the fourth option of planning is actually when the care is needed, all right? So let's take a look at our life care plan. Our life care plan is for those clients and families that find themselves in need of long-term care. Whether it's a gradual process and you see the decline occurring, or it's a crisis. More often than not, it's a crisis. The family sees it, but they don't see it, and next thing you know, it's happening. And the family is here without the planning, without the protection, not knowing where to go and what to do. And when that happens, fears and concerns start to run wild. How do we protect the house? How do we keep the income? How do we get mom or dad the best care possible? Where do we get the care? What providers do we use? Well, the life care plan addresses all of those concerns and then some. The way it works is that we divide all of the concerns into three different domains: the legal domain, the financial domain, and the care domain. All right. By organizing it this way, we're able to kind of divide and conquer and address the concerns. Now, each of these domains has a goal that we help the family accomplish. Okay. And that goal for the legal domain is protect the assets. How do we protect the most assets possible? The financial goal may seem obvious, but it's how do we get Medicaid to pay as soon as possible. All right. So legal goal is let's protect as much as possible. Financial goal is let's get Medicaid to pay when it's necessary. And the care goal is how do we get our loved one, our mom and our dad, how do we get them the best care possible? Okay. Now, that may seem obvious, but when you're working with, and we do it all every day, when we're working with stressed out caregiver children and spouses, they need all of the united help that they can get. They need a team, and that's what we offer. That's what this life care plan is. So, how do we accomplish these goals? Well, we achieve them by going through different strategies. Okay. So the strategies that we undertake for the legal domain and protecting the assets, as we've been talking about, asset protection, we'll deal with estate planning and probate avoidance. And we'll, of course, undertake incapacity planning, which is the powers of attorney and the healthcare advance directives. When it comes to achieving the goal of getting Medicaid, there's restructuring of assets. There's inheritance preservation, which really utilizes the what's called the spousal refusal, okay, making sure that a quality of life and a standard of living is maintained for the spouse or the children. And then it's utilizing the income properly. So there's community Medicaid, and then there's what's called chronic care Medicaid. Community Medicaid is in the home or some assisted livings. Chronic care is in the nursing home. We utilize the income differently in each of those scenarios. At home, we utilize something called a pooled supplemental needs trust, which we'll talk about more next week. Okay, but that's how we're able to shelter the income. And now, the good part, when it comes to the care, because very honestly, these are the issues. These care issues are the ones that the families appreciate the most. It's these care issues on top of the financial and legal work that really brings that peace of mind. And we accomplish getting the best care for mom or dad through routine assessments, through coordinating the care, the transitions, placement. Is it time for this? Is it time for that? The coordination of the care and the vendors is crucial. And having an experienced firm like ours do it, again, peace of mind is what's going to happen. There's a lot of advocacy between the attorneys and what we call our elder care coordinators. So the way we operate here as an elder care law firm is we have the experienced elder law attorneys and we have our elder care coordinators. On staff here, we have a geriatric social worker, Dana, who was on the webinar with me a couple weeks ago. She's our lead care coordinator. And we also have Nicole Ferrara, who is a board certified patient advocate. And the two of them work with the attorneys every single day to make sure our clients are getting the best care possible, even during a pandemic like this. All right. And it's been difficult, but we're doing our best. And finally, there's intervention. Those advocates are intervening when there's a crisis. The care hasn't been up to par. The bed sore exists. Mom keeps falling. There's different places where intervention becomes crucial. And again, our elder care coordinators are able to get in there and intervene and help the family through the process. Okay. Now, of course, with these different strategies, there's different tools that we utilize that we've been talking about. So on the legal side, again, we're using the trusts, the powers of attorney, the healthcare directives. On the financial side, we're using the Medicaid and the pooled trust for the income. On the care side, again, the real tool, the sneak attack that we have is these elder care coordinators. Okay, so those are the 4 plans that we utilize. The probate plan for simpler, younger, black and white situations that are folks that are healthy. Then we have the probate avoidance plan, which is for older, still healthy, other varied assets that they want to plan for and keep things simple for the family. Of course, we have the elder care protection plan, which is a very comprehensive service, not just hit and run trust dealing and then leaving the family on their own. We really support the family and the trustee as they protect those assets and prepare for care down the road. And ultimately, we have the Life Care Plan, which is our signature service. This is what we're known for throughout downstate New York. We've got clients in Westchester, we've got clients in New York City, the different boroughs, and of course Nassau and Suffolk. It's this life care planning service where all of our services accumulate, and we're able to really provide ultimately peace of mind on the legal, financial, and on the care front. Okay. Now, practically though, how are we doing this all during COVID? How are we doing this during a pandemic? And the answer is yes, we are doing it. We're undertaking video consults. We're helping clients, a lot of phone conferences, Zoom calls, FaceTime calls, parking lot signings. Okay, so right now we've been doing signings outside the back door of the building. You can see the mask and the gloves. It's no contact. All the documents are received and reviewed by the client before they actually come to sign. But again, papers are on the table, pens are on the table, or you bring your own pens. Attorneys step away, clients come in and sign. Gratefully, though, we now have, Governor Cuomo did this, we have digital notarizing, which we could do through the camera, through Zoom, as well as remote witnessing. So we can have wills and powers of attorney signed without even being in the room. That's all currently through May 7th. Hopefully that'll continue on after, but that's what we're looking at right now. Now, as I start to wrap up, we're at our time here, and I'd be happy to answer questions after this. As we start to wrap up, let me share a very important point. And that's about whom you choose to work with when starting your planning and your protection, okay? If there's one thing you take away from this webinar, let it be this. Just like the planning we've been talking about, you want a firm, you want counsel, you want an advocate, you want an elder care and planning firm that will provide comprehensive strategies and solutions no matter what twists and turns come up. You want a firm that's experienced. I can't tell you how many times we've had to fix plans and documents done by lawyers that weren't estate and elder care attorneys. I'm not exactly sure why clients go to attorneys that don't focus. This is an area of law that requires experience. The analogy we hear about is, you don't go to your general practitioner doctor if you need a cardiologist. This type of work is very specific. It's all we do. All right. It's all we do 24/7 for 22 years, and there's not enough time in the day. So who you pick, you want to make sure that they are experienced and this is what they focus on. Okay. You want a firm that's thinking about your future. As an elder care firm, everything we're talking about here and the estate planning we're talking about, even for the younger folks, is all about you and your future. Making sure your plan is flexible and fits you and their circumstances as you age, okay? So please, if you have questions, you can call, you can email. My email address is right there, and I'll be happy to answer some questions just as soon as I clear up my screen right here, all right? So thank you. Do we have any questions? Let me see. We do have a couple here. Let me find them for us. Please feel free to answer more questions. Can a revocable trust morph into an irrevocable trust as time goes on? The answer is yes. It's actually going to be a complete amendment of the revocable into an irrevocable. So quite often, practically speaking, it's easier to just start with a new irrevocable trust and have the assets transfer from the revocable trustee to the new irrevocable trustee, okay? And a comment that went to go look to the website to look for next Tuesday's webinar on Medicaid. That'll be on by Thursday of this week, okay? And again, if you enter your email, there should be a little pop-up on the website. Enter your email, you'll get on the list, and we will definitely invite you to attend next week's webinar, all right? Any other questions, folks? Let me see here. Where's my questions? Let me see. Irrevocable trusts have been a roadblock. Okay, so the question is dealing with financing and assets down the road. If somebody has an irrevocable trust, how does it work with what's called a reverse mortgage? How can they protect their assets? So when you have an irrevocable trust in place, the goal is protection. And traditional banks and financial institutions don't really want to work with an irrevocable trust that is built to protect the assets and protect those that set it up, because they're going to have a hard time going after if there's any type of default. So a reverse mortgage is a tool that can be used for somebody who is over, I think, 60 or 62 years of age at this point, and they can get equity out of their house. A reverse mortgage is still able to be utilized within an irrevocable trust. It's a little complicated, but it's certainly something that can be used to get equity out of the house and help the senior live in their home, all right, for as long as possible. Any other questions, folks? Otherwise, we're going to start to wrap up a little bit after 3, and I'm grateful you all stuck around. Where's our office? We're based in Melville, all right? With that, I want to share one other point. So in this day and age of this pandemic, this unfortunate situation, we're also doing document signings, okay, at people's homes, literally on their front lawn or in their driveway. Again, no contact. If folks are unable physically to come into the office, it doesn't matter where you are, we'll come to you, all right, within reason. But the ideal situation is that you'd come to the back of our building here. Again, no contact signing. But we are in Melville, and as I said, we've been working throughout the downstate area for 22 years, Long Island, Queens, etc. All right. Please let us know. Let me know if you have any questions. You can reach out to me directly, brian@tullyelderlaw.com, or the phone number is 631-424-2800. Thank you very much, and stay safe.